So I didn't actually know about this case. This is from 2019. This is one of the Extinction Rebellion early cases. In fact, this case was just a couple of months after my last case, when they took my driving licence off me, and it was around the time I was in community service, but I got out of community service, and then this case was actually exactly at or around the time I actually got out of community service, because I was ill, and then this case happened at the same time, and then this was like literally just going into Christmas, and then by the new year, by the end of January, like literally just about a month or so later, a little bit more than a month later, then the whole country was in lockdown, right? Now I knew Extinction Rebellion existed at the time, but they were only just kind of getting into the newspapers and public. And this was towards the end of my main campaign, because obviously I couldn't drive anymore, right? And then we went into lockdown, you see, and there was all those other Extinction Rebellion incidents, like, that tunnelers and all those other things, which were really big cases. Now, I didn't know about this case. I knew there was some of the members of the House of Lords supporting Extinction Rebellion, because I've seen some of them turn up at protests. Like, they had a soapbox and people talking, and they had one of the Baronesses. It wasn't this Baroness. It wasn't this Baroness Jenny. It was a different one who I saw on the soapbox, but I was looking for her to find out what her name was, because just for an example of members of the House of Lords who have been at protests, right? Like speaking and participating in them, and knowing that they're connected with parliamentary causes under the law of parliamentary agency, and they actually should be speaking out about or advocating their rights, because it's Parliament's responsibility. Like, obviously, it's the Attorney General, really. In fact, this case was in the High Court, and it was between this Baroness Jenny and the Met Police, right? The commissioner, so the police commissioner of the Met Police, the chief, right? Between him and a member of the House of Lords. But I don't know why she was representing, because all matters that could possibly be a contempt by the authorities, even by the police, are meant to be done by the Attorney General, right? And Baron Hermer wasn't the Attorney General at that time, right? So but obviously a member of the House of Lords can make a representation, but they're meant to actually just write a privilege letter, or get the Parliamentary Papers Act certificate, which is like a safeguard, really. But what she did is made just a representation, but they won. But they should have won with a certificate to prove a right, not like a common law argument. And what actually happened is it's Section 14 of the Public Order Act 1986, which allows senior police officers to impose conditions to prevent assemblies and things like that. Now, what it is you need to know what this actually is. What it actually is the power of a senior police officer to issue and write a dispersal order, so then persons can be removed and arrested. But this is the thing, right? I know that this case had its own representation, and at the end, this case proved that it was actually unlawful. It was not lawful, that order, so it couldn't be enforced. Well, that's what we want to prove, but the way they've proved it is just through legal arguments. They haven't actually kind of like, well, I don't actually know what the legal argument was, if it was a common law argument on the basis of legislation, or if Baroness said, but this is a right. But really, members of the House of Lords can write a privilege out. They can write a notice of privilege, or they can get the Speaker or a Clerk of Parliament to write a certificate out under the Parliamentary Papers Act, which she should have done. But I don't think she's done that, but they still won, right? But the only thing is that if this proved that order was illegal and not lawful, so they can't do it again for a parliamentary cause. Now, so how do they have the Public Order Act, and what's the Public Order Act for? Well, it can be, there are many protests which aren't a parliamentary cause, right? And aren't privileged. Like, random football match incidents, or big, huge music arenas, or just like, random public riots, or it could be illegal immigrants, anything other than an official parliamentary cause, right? Now, this is the thing. This is the Public Order Act 1986, and this is really important because these are under the Public Order Act, right? And the first Public Order Act, which was, I think, in somewhere like 1936, the exact year escapes my mind, but I've just been reading it recently. There's a government review of the Public Order Act, okay? And all of these Public Order Acts, the very first one is still in effect. It's still in force. And it says that when there's any protest or demonstration and people are arrested, right, whether or not they might have dangerous weapons or implements or anything like that, one of the things to be checked for is political objects, right? Political objects, particularly ones like a petition, is a petition is a political object, right? It's a political object, is a petition, which confers special protection, particularly if you're sharing it or canvassing it or even an abstract of it, right? And this is the thing. The Attorney General is not doing that, neither is the Chief of Police, but this case was against the Chief of Police. So if the Chief of Police was refusing to check and acknowledge these special protections, then obviously it would be right for him to be challenged. But it's not just the Chief of Police, it's actually the Attorney General, right? Because when it's a parliamentary cause, we don't have to pay for it, and we're meant to be protected by right of law. It's not common law, and it's not meant to be criminal, right? And that's why you're meant to have the Attorney General has to give consent, right, to see that you can be prosecuted. When the first Public Order Act was enacted, there was still a 20-person limit on privileges, remember, until you get consent from a court. But when you got consent from a court to attach more than 20 people with privilege, then they were all privileged, right, officially. And I think that actual document will get the seal of the court on it, almost like a probate document, right? And then it could be shared. Obviously, everyone might not have a copy of it, but they could. But also it means that you can talk about it, voice it, give announcements about it and so forth. You didn't necessarily have to have an additional document. But this is where the Parliamentary Papers Act comes in, because, if you need certainty, what's this certificate is for? Certainty, to certify. If you need legal support, that's what the Parliamentary Papers Act's for. But that's why the Attorney General's got to assess people, right? And the problem with this case is that the Baroness had to do it, but if you want to approach Parliament and ask Parliament to do it, then they can. But I don't know whether Extinction Rebellions was officially a House of Lords case or a House of Commons one. There's no doubt that they had petitions to the House of Commons, and they've got their own registered campaign group, which is a political body and is so under the Value Added Tax Act and all that. It's an official recognised body with a political objective, right? Now, the thing is that this case has actually decided that a police officer put in his hand, senior police officer, actually using this law to write out against a parliamentary cause is not lawful, right? They can't actually do it. That's what this case decided. Now, the thing is, when we get to like the Stop ULEZ, and they've been writing out these dispersal orders. Now, the dispersal order is the same legal principle, but it's in a different act. It's in this section 42 of one of the other acts. But even though it's a different act of law, right, it still associated law to this, right? It's associated legislation because, you can only write one of those orders first if there is always not harassment, which can be prosecuted against, and that harassment has to be prosecutable harassment, right? And then, that harassment, they can only write out a dispersal order if there is harassment present, right? But that order is exactly the same as this, in the sense that it is an order written by a senior police officer which has effect on members of the public and makes them not allowed to be in a certain area, right? So it's the same thing but a different act. Now, the legal basis of which they won this case on, right? I'll find the document. I'll find the court order from it, right? I'll find it and I'll put it on the website. But I can guarantee you now that they've actually proved that the police aren't allowed to write out, senior police aren't allowed to write out an order against these parliamentary political causes. It's not lawful, right? And so if that is for the whole of London such a really, really serious, because this section 14 is a very serious order that a police officer would write out. Now, the thing is that the section 42 order, which a police officer similarly would write out, right, is a less serious order. It's a more minor thing than on a scale than this, right? So, and it's officially in public order and associated legislation, right? So I cannot possibly see how those Section 42 orders, which, let's summarise it, it's an order written by a senior police officer which would supposedly give them permission to break up a group of people, right? And what the outcome of this case is that they're not allowed to do it with these parliamentary causes, right? So how can they do it with the Section 42? Because it's less serious and less important, right? So if the basis applies to this Section 14 of the Public Order Act, which is for a bigger area and a more serious thing, right, and that's not lawful, then how can the Section 42 be lawful? How can the Section 42 one be lawful if it's just a bit of paper that a police officer writes out? It can't be, can it, right? So when that case was won in, just before Christmas in 2019, how are police using these Section 42 dispersal orders on acknowledged parliamentary causes? And the most important thing that I've found is that the first Public Order Act, which is still in force and still in effect, the Attorney General isn't acting at all. The Attorney General's now, I can see why the senior police officer's not acting when he's meant to, because he's opposing it. He's actually in opposition. You're not allowed to be in opposition. And in fact, further than that, right, under in the parliamentary practice book by Sir Thomas Erskine May, which I've now found misconduct against petitioners and others soliciting business before either houses of Parliament to intervene, obstruct, right, or interfere is a contempt. It's a contempt offence, right? It's a contempt offence. And here, the Met Police Chief is interfering. And he's actually in court against this Baroness, Jenny Jones, or whatever she's called. What is actually going on is it's actually more serious than that, because they actually won this. They won this and they said that it was unlawful. But what Jenny Jones hasn't done is I think she's just argued it under the common law that it's unlawful. What she hasn't done is she hasn't got the Parliamentary Papers Act out and said that, they can't be prosecuted, right? Which is what the Attorney General, you're not, by the Public Order Act, you're not meant to be prosecuted unless the Attorney General has given consent. Why? Because if you were to be prosecuted and it was illegal, then it would be a contempt, right? Which is what it is. It is a contempt. And in fact, the Parliamentary Papers Act proves that it's a parliamentary thing, right? And therefore, if a court or the CPS or the police actually disobeyed that Parliamentary Papers Act certificate and affidavit, then they would be in contempt, surely. But no one gets these certificates, right? But actually, what's happened with the outcome of this case in 2019 is that they've proved that it was unlawful. So what's actually gone straight over the top of everyone's head at the moment is that, hey, just a minute, well, the outcome of this case is that it was unlawful against the law. But what law? Well, actually, it's against the law of contempt against petitioners, surely, and others soliciting business to either houses of Parliament, right? So that means that it's already been proved that the police chief is in contempt by this case. This case has already proved that the police chief was actually in contempt, but they just haven't said that. They haven't said, oh, by the way, the outcome of this case is this was unlawful. And by the way, why is it? Well, because it's against constitutional rights, yeah? So I didn't know about this case. So that Section 42 dispersal order definitely is unlawful. When this Section 14 one was proved unlawful for a bigger and wider area. And I think this is just like gone straight over the top of everyone's heads. This was 2019, so this is when I was when I got out of community service, and then the pandemic lockdown. In fact, everyone got out of community service because the whole probation service got closed down. So 2019, 20, 22, 23, 24, 25. We're 5 and a bit years. We're almost 5 years and a few months now after that. Now, if people haven't realised this, you see that this Section 14 being unlawful against the parliamentary cause surely must mean that those Section 42s are, because they're on the same principle and basis, and it's the same thing what the police are doing, and it's the same species or category of parliamentary cause which we're in question, which we're talking about. So this is the page from Sir Thomas Erskine May. Misconduct affecting petitioners and others' business before either house. Petitioners and other persons soliciting business before either of the Houses of Parliament, acts of contempt, constituting contempt, right? Because they're under the protection of the High Court of Parliament, right? So this is it here. This is it here. Extinction Rebellion wins landmark legal challenge to Met Police ban on peaceful protests. So, I mean, how can a Section 42 be lawful for this similar species of particular species of demonstration or protest, right? Not a non-privileged one. Because let's not forget the first Public Order Act and, the whole right to petition, which they seem to be thinking some kind of European Euro rights is taken over from it. But it hasn't, because the first Public Order Act provides for it, and all of the Met Police Acts, all of the acts that actually create and form the Met Police, invent the Met Police, say that all privileges, including the privileges of London, citizens of London, are to be retained and enforced as if that act hadn't been enacted, right? And here she is, Jenny Jones, Baroness Jones of Musselscombe, right? This is her. She's a Green Party member of the House of Lords, right? Now, she's done brilliant in 2019. She's done absolutely brilliant to challenge the Met Police. But I don't think that she fully actually knows what she's done, or maybe she does. I don't think she does, though, because what she's actually done is proved that the Met Police chief, it was unlawful, not legal. But why? Well, no matter what arguments she's put forward, that they are undoubtedly that it's political rights, okay? But I don't think that they've clicked. I think that it's gone over the top of her head, this Baroness. I don't think she's quite realised and clicked that, hey, actually, and by the way, this is a contempt of Parliament, and the Met Police Chief is in contempt because when he actually, in the very first Public Order Act, the Police Chief has got a duty to uphold those rights and not oppose them, because you got illegal police canvassing in Representation of the People Act 1983, Section 100. Police cannot oppose political causes. They can't put their hands in opposition to it. Writing one of those orders out is putting your hands in opposition to it, right? Why? Because it's a contempt of Parliament. So these Section 42 dispersal orders, which are very small ones, a minor one, or in comparison to that Section 14, they're actually a more petty version of it. So if the Section 14 is illegal on the same basis, it's a petty version of the exact same thing, right? A smaller version. A senior police officer puts his hand to an order, writes an order out to disperse people, right? Section 14 is for more serious, important matter, and the Section 42 is for a more localised matter, right? But it's the exact same basis and principle, right? So the Section 42 one cannot be lawful because of the outcome of this case. Surely it's proved that they're all illegal on the basis that the police can't oppose a political cause or intervene in one. And they're only allowed to really do it when it's not a parliamentary cause, and when it's not a cause to either the House of Parliament or Lords or the King, which you can have. How about all those? They had loads of kids started rioting and smashing shops up, right? That's not a parliamentary cause. Football match riots are not a parliamentary cause. Music festival riots, or even if you had a music festival with loads of 20,000 people against the police at a music festival, because if they got thrown off for whatever reason, an injury or incident or God knows what, and they want to, we demand to be let back on, that's not a parliamentary cause. So the police can do it in that instance as well. We're not saying that the police don't have those powers at all, but we're specifically talking about parliamentary causes, and that is protected by English rights. And that's what it's about, this